Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris. And today our guest is Philip Lamar, counselor and mediator with the Positive Solutions Group, LLC. And we're going to talk about what you need to know about mediation today. Thank you, counselor, for coming.
And thank you for having me. I'm always delighted to have an opportunity to talk about mediation.
Okay. Well, why don't you get us started by tell us a little bit about yourself and how it contributed to your becoming a mediator.
Thank you. Well, I'm an attorney, and after law school, I spent 4 years working with the General Assembly of Virginia, drafting legislation. And from there, I joined a large law publishing company as an executive and spent 23 years there. And then started a law firm, and with two colleagues formed Positive Solutions Group, a mediation firm. I have studied collaborative law, and I'm certified to mediate cases in general district court and circuit courts, and I have mentor status, which means I can help other people learn to be mediators. And so that's sort of the thumbnail sketch.
Okay, well, let's talk about mediation. I mean, there's a lot of different forms of mediation, or are there? Or is it just mediation?
Well, thank you. I know that in a previous interview you did with John Grimes, mediation was covered pretty well, and I know that's at your website. But for viewers who haven't had a chance to look at that, I'll talk a little bit about it. Mediation is basically just a couple of people sitting down and working out their own dispute and how it should be resolved. The difference is they do it with a facilitator who is the mediator. And the mediator is a person who doesn't have a stake in the outcome of the case. He doesn't care if which one party wins or the other party wins. And so that's essentially the basis of it. And the idea is, the goal is for the parties to reach what is a fair and equitable agreement. And mediation is in maybe 4 or 5 different stages. And the first part is each party has a chance to explain very fully what the situation is, why they're there, how they feel about it, and how they'd like to see the matter resolved. So both parties get to do that, and they get to be heard. The second stage is identifying the issues. And often we find that the issues are not as clear as people think they are. There's a lot of other stuff going on around the main issues. So we identify and narrow and clarify issues. And then after that, the parties work together to sort of create their own solutions. And once they create their own solutions, then the result is written up in an agreement. And that has that's a contract that's enforceable by a court of law. So that is essentially the process. If I may, I'd like to just talk for a moment about the benefits of mediation.
Yeah, well, that's the best part of it.
Yeah.
How do I benefit from mediation versus going to court or filing a lawsuit or some other means?
Yes. Well, one of the chief benefits is that the parties have self-determination. They get to control the outcome of the case. They don't hand it over to a judge to decide. They decide what's going to happen. And they save a lot of time. Sometimes if you're going to court, you have to wait half a year before you get your day in court. With mediation, you can probably do it next week or the following week and move right through it. So if you save time, it often follows that you save a lot of money.
A lot of money.
Yeah. And if you think about it, if there are two parties and they're each paying a lawyer $250 an hour, that's $500 an hour that's being spent. And if they can come to mediation, they can often they can do it without attorneys. Attorneys often will come to mediation.
Okay, that's
It's
one of my
fine.
questions.
Yeah.
Well, one thing is preserves relationships.
Indeed, that
Okay.
is a very important one, and particularly in family cases, divorce cases, cases dealing with parents that are elderly or disabled, and those sorts of things. It's
Yeah.
a very, very
Everyone comes to agreement of the minds, you might say.
indeed,
Mhm.
yes, and one other item is everything's confidential. What happens in mediation stays in mediation. You go to court, everything's
It's
public.
public record, right?
Yes.
Well, what types of cases are appropriate for mediation in your?
Well, in my view, just about any case that's not a criminal case.
Okay.
So, the type of case that most people in this part of Virginia think of when they think of mediation is divorce. And when I say divorce, I really am including separation, support issues, spousal support, child support, parenting, that would be custody and visitation, and the equitable distribution of assets and sometimes debt. But again, this was covered pretty thoroughly in your interview with John Grimes, and so I won't dwell on this, but I can move on to some other areas.
Okay.
So another area that is very appropriate for mediation is personal injury. And a good example of that is an automobile accident where there's been damage to property, or there has been injury to a person, or somebody died. And these cases, the parties don't come with emotional stuff. They're not interpersonal relationships. These people are usually strangers.
Mhm.
So it's usually about the injury. Is there liability? Is somebody at fault? And if so, was damage done, and how much money should be paid? So it turns out to be sort of a monetary negotiation. And there are lawyers who specialize in this, and usually an insurance company shows up, and these people know how to work with a mediator, and it usually goes very well.
Other parts are like stocks and bonds, or brokerage cases. Do you have any of those?
I have not personally had a case like that. I've had a lot of business cases.
Okay, and what types? Can you tell us?
Well, in the lower court, we see a lot of landlord-tenant,
Okay.
and it's a great way for those issues to be resolved, because often the amount of money involved is low, and hiring an attorney to help is sometimes the attorney costs more than the $300 they're fighting over.
Right, the damages. Yeah.
So we see a lot of those in the lower court. But then there are more sophisticated issues, contract issues between, well, it could be just a couple small companies with a contract on the back of a napkin, or complex, large contracts between large companies, franchise agreements, that sort of thing, or leases, not for an apartment, but rather for a warehouse or a store and a shopping center, those sorts of things.
Now, most of these, using a mediator has to be in the contract itself, or can be outside the contract, and people say, well, why don't we use a mediator to resolve these issues?
Right. We see more and more that mediation clauses are involved in the contracts. Historically, it was usually arbitration, which is quite different than mediation. But now we see provisions that require mediation, and if mediation fails, then they go to arbitration. But usually, it's just people finding their way to the mediator. And going, and also there are a lot of employment issues between employees and companies.
Okay.
For instance, if an executive breaches his or her non-compete or non-disclosure agreement, that could be brought to mediation.
Okay. Now you brought it up about arbitration versus mediation. Can you tell us the difference between the two?
Oh, certainly. In mediation, as I mentioned earlier, the parties have self-determination. They figure out what the result is going to be with the help of the mediator. In arbitration, the parties present their case to an arbitrator who is not necessarily a judge, is not necessarily a lawyer. It's just somebody the parties have chosen to hear their case. And the arbitrator decides who wins and who loses. And there's the disadvantage of there are no rules of evidence unless the parties agree on something. So it's sort of free form, and the arbitrators usually let the parties talk a whole lot about what they get everything off their chest. So the big difference is in mediation, the parties decide. In arbitration, the arbitrator decides.
Okay. So now, what is the negative about a person going to arbitration versus the mediation?
Well, I think it's just that they lose control.
Lose control of it.
And often people feel compelled to bring attorneys to arbitration, which adds some level of expense.
Well, what happens if the case doesn't settle? You're saying we come to agreement of minds, and each one walks away happy with the situation and the experience. What happens if they don't come to a meeting of the minds and the case doesn't settle?
Well, in mediation, of course, the options are they can settle. Sometimes they will settle some of the issues. Maybe they have 5 issues. They'll work 3 of them out, and they'll take the other 2 to court. Sometimes they will start out in mediation this far apart, and at the end of the mediation, they're really close. And so often they'll freeze their offers right there until the trial date, and they have that period of time to get together. But freezing them keeps them from backsliding and going back to where they were when they started.
So mediation gives you a few more options.
It does.
That you wouldn't have ordinarily going to court.
No,
or
it's
arbitration. What training do you go through to get to this position?
well. There's some formal training required by the Supreme Court for those who want to be certified. Certification is not required in the Commonwealth, but it is it's a good thing to have, and so that requires some, I think, 40 hours for the basic training, and then some hands-on going to mediations with people who are mediators, the mentors, and then there's for different levels. There's certain training for general district court, and there's additional training for circuit court, and then if you want to do family law, it's another level, and each level requires more training.
Okay. Well, this is going to take a break right here and say this is the Neighborhood Law Center, and I'm your host, Melvin Burris, and our guest is Philip Lamar, attorney and mediator with the Positive Solutions Group. And our topic is what you need to know about mediation. And going back to that subject, I would say we talked about mediation, what it is, and how do you get started. Now, we haven't talked about how do you prepare for a mediation case or to mediate?
Oh, how do I prepare for a case? Oh, good question. If it's a complex case, I ask the parties or their lawyers to send me briefs on what the case is about, so that I go into the mediation with a running start. And then I also have to change gears from the lawyer mentality to the mediator mentality, completely different, and start thinking about mediation and go back over mediation ideas and thoughts about how to make the mediation work. That's basically my preparation for it. Yes.
Okay. And do the other side, you said, you look at the pleadings. Do normally someone comes in with an attorney, or they don't come in with their attorney?
Well,
or they have that option?
Well, actually, I sometimes they send me the pleadings, but usually what I ask them to do is summarize
Mhm.
for me, so I don't have to spend my time and their money reviewing the long pleadings. So I ask them to.
So the attorneys are not involved?
No, this would be the attorneys.
Oh, I mean,
providing
but they're not involved once you start the mediation?
Oh, actually, very often they are.
Oh, they are, okay.
For complex cases, they are, and I welcome them.
Mhm.
A good attorney is a big help in mediation. The client can, if they receive a proposal from the other side, and they're wondering, is that a good proposal? They can turn to their attorney and say, could I do that well in court? And the attorney can make them feel good about
Okay.
either accepting or rejecting an offer.
All right, well, we talked about costs at one time. If the attorneys are involved, how much does usually a mediation cost a person?
Well, that varies widely and depends on the case, and it also, we like to compare it to going to court. And while attorneys would come to mediation, the idea is that it does not take as long in mediation to get the job done. And so there's not the attorney's fees for doing discovery and pleadings and motions and
They've already done
hearings
that.
and yeah.
Okay.
Mhm. So it does cost something. It's
Mhm.
not free, but it's
Do you work by the hour, or you guys do a do mediators do a flat fee, or do they do per hour?
well, all
or
media.
combination,
I think the firms that I know about charge by the hour.
Mhm.
Mhm. And depends on the case what that charge is.
Okay, so the quicker the solution, the less costly the case. Now, a question I should ask is, how should one with a conflict proceed in determining which option to take? There's many options here.
Yeah, well, I think they should look at the whole, all the things that are available to them. And I like to look at it from the simple, least expensive to the most expensive, most complicated. The least expensive is just the two of them sitting down in the coffee shop and talking about it and working
Mhm.
it out, negotiating. The next step would be mediation, which is just like the first step, only you got a mediator and maybe no coffee. And then the third option would be arbitration, which we've already talked about. And then the fourth would be litigation.
Mm-hmm.
And I would recommend that people do their homework. Maybe they go online, read about these things, call some attorneys, call some mediators, and then figure it out. Mel, if I may, there was one thing that I did want to
Help. Yeah, you're the expert here. You let us know.
Well, I
about
think
the
this
mediation.
is important because this is a type of case that is very appropriate for mediation, and people don't know about.
Mhm.
Many people don't know about, and I'm seeing a lot of them in my practice. And these relate to estate matters, and these involve relationships between family members. And when these are taken to court, the family members often end up in somebody becomes really bitter, resentful, and people can just, the family just comes apart.
Well, give us an example of an estate matter.
Very good. One I think that we see a lot of is that may be related to an elderly disabled parent.
Mm-hmm.
And the type of issues that come up are like, who's going to be the agent for his power of attorney? Where is he going to live? Is he going to live at home and have people come in and help him, or is he going to live in an institutionalized home where there's care? Who's going to take care of his money? Who's going to make medical decisions for him? All these things are things that can be answered in court, but if they're answered in court, probably make somebody upset. So a good way to do this is to take it to mediation, let the people work on those issues as well as the family relationship. And by doing that, they can go back and focus on what's good for dad, what's good for mom, without having the family fight.
Okay. Are there any others that you think are ripe for this type of?
Yeah, I
topic
do.
or
It's when people, when there's a disagreement over what mom and dad left
Okay,
the children.
that comes up all the time.
It does.
Mhm.
And so, you know, and it's hard to establish values for these things because, like, sentimental things
Mhm.
like granddad's pocket watch,
Yeah.
what's that worth? I had a mediation where 4 children inherited a farm. And it was like, is the property next to the pond worth more than the property next to the road? And so a lot of work had to go into figuring that out. So those are the
Well,
main.
now that you mention that, that's a good way to do it, mediation, rather than going to court to try to get the land partitioned.
Indeed.
Which is the extreme, you might say, but sitting down and as siblings and trying to work it out, get a better feeling for your siblings, as well as, you know, mom said she wanted me to have this over here with the orchard, or mom said, so that works out very well. Okay, one thing I understand is mediation clauses are being used more and more
Mhm.
by businesses. How does that work out?
Well, you know, I know they're being used more. I put them in all the contracts that I draft, unless the client tells me not to.
Mm-hmm.
But I haven't seen a lot of people who have actually come to mediation based on that clause.
Okay.
Maybe they don't tell me that's why they're there, but I don't hear a lot about that. And it may be that people who will put the clause in their contract really don't need it because they were dealing in good faith.
Okay.
You know.
All right. Now, we mentioned before about the court versus the arbitrator. Mediator not being a judge, jury, or arbitrator, or therapist, because it seems like
Feels
sometimes
like
it's
it sometimes.
you need that. How can a mediator help the parties in dispute to resolve their issues?
Very good question. Well, as mediators, we learn certain communication techniques, and we find that most disputes are the result of failed communication, no communication, miscommunication. So a big part of what we do is that, and I think chief amongst them of the techniques is the listening skills, the active listening, which is a marvelous thing to know about. Either it just helps people get along in their daily life if they have that training. And basically it just means that one person listens to another person without interrupting, and then asks questions if they don't understand things, and then tells that person back what they heard, so that person knows they've been heard. And the key here is that if somebody feels like they've been heard, they will relax
Mm-hmm.
and they'll listen to what you have to say.
Okay. So how long does a mediation usually takes?
Wow.
Typically, I mean, it's not.
You know, the garden variety landlord-tenant, maybe 45 minutes. Couples, divorce with children and assets could take several sessions of maybe 4 hours.
So each case is fact-driven, as to.
Depends on the complexity, assets, how much money's involved, how many parties are involved. Yeah.
Okay. Well, it looks like we're running out of time here. So I'd like for you to kind of sum up with something you would like our audience to remember about mediation.
Well, I would like for the audience to keep this in mind. Traditionally in this country, when people have a conflict, it's call the lawyer. I would suggest that they call the lawyer and call a mediator so that they can discuss the appropriateness of their case for either route and make that determination on their own. and make it an informed decision. So that would be, I think, what I'd like to leave with. I'd also like to point out that the Commonwealth of Virginia has a couple of programs. One is that if you go to General District Court, there is always a mediator in the room on docket day, and the court can assign a case to mediation.
Okay, if they want to call you, what is your number and website that we can?
Yes. Which camera are we looking at? That one. Can you do this? Okay. That would be it. And
Well, what was it? Could you
oh yes,
verbally?
yes. Well, the number is 434-979-0821. That's one of the numbers, and that's I'll just leave it at that. And we're Positive Solutions Group,
And your website is? If you want to go to your
yes,
website to
it's-
learn more about you.
It's Positive Solutions GRP, short for group.com.
Okay. Okay, well, this is Melvin Burrs of the Neighborhood Law Center. And I want to remind our audience to go to the website, neighborhoodlawcenter.com. Click on shows so you will see this show and previous shows that you may have missed. And also you can go to YouTube and type in Neighborhood Law Center, and our programs will be coming up on that. Also, for those who live in the area, we're on Mondays on Channel 13 at 10 p.m. on Channel 13. So thank you,
Thank
Counselor,
you.
for coming.
Thank you for
Thank you, folks, for watching in, and we'll see you next week. Peace and God bless.
Yeah.